Deputy Merritt, you told your partner I was nobody. You were right about one thing. Last night, I was nobody. And nobody just ended your career.
They walked into the Oak Haven County District Courthouse that Tuesday morning like men who had never once in their careers been told no and fully expected that streak to continue indefinitely. Deputy Craig Merritt came through the glass doors first, broad-shouldered and unhurried, his utility belt creaking with the weight of everything he carried, his buzz-cut head turning slowly from side to side the way a man does when he owns every room he enters. His partner, Deputy Shane Fowler, followed a half-step behind, younger, thinner, still wearing that eager-to-please expression that rookies carry before the job grinds it away. They bypassed the civilian line without a glance, flashed their badges at the court officers with the casual indifference of men who had done it 1,000 times and strolled through the metal detector like they were walking into their own living room. The marble corridor of the courthouse hummed with the morning noise of the justice system. The rapid clicking of heels on polished stone, the low murmur of lawyers leaning into their clients' ears, the smell of old wood and fresh coffee drifting from the clerk's office down the hall, the muffled crying of a woman on one of the long wooden benches near the water fountain. The building smelled like consequence. To most people who walked through those doors, it was a place of reckoning, of carefully held breath of outcomes that could shatter or rebuild a life in the span of a morning. To Merritt, it was just another Tuesday. He was still laughing about the night before. "She actually quoted the Fourth Amendment at me," Merritt said, shaking his head with a grin that stretched all the way to smug. "Standing there in sweatpants at a gas station at midnight, quoting the Fourth Amendment like she was on a debate team. I almost felt bad." He did not sound like he felt bad. He sounded like a man recalling the highlight of his week. "Threw every word she had at me and still ended up in holding cell 4. He slapped Fowler on the back hard. "That's the thing about people like that. They think knowing the law is the same as having power. It's not." Fowler forced a laugh. It came out thinner than he intended. What neither of them said, what neither of them had thought to wonder about, even for a moment, was where that woman was right now. They had not checked. They had not asked. She had been processed, booked, and filed into the machine, and as far as Craig Merritt was concerned, that was the end of her story. But here is the thing about stories. Sometimes the person you think you've written out of the script is already standing at the ending, waiting for you to catch up. The woman they arrested at that gas station had not gone home. She had not disappeared into the system and gone quietly. She had spent the night in a cold, concrete cell with a borrowed pen and a piece of paper writing down everything, every word, every timestamp, every detail with the precision of someone who had spent 2 decades separating truth from fabrication for a living. And right now, while Merritt was laughing in the hallway and Fowler was trying to settle the knot of unease in his stomach, she was getting ready. She had been waiting all night for this morning, and this morning was about to begin. The night before had started the way most of Judge Renata Cole's nights ended, during conference weeks in exhaustion so deep it had texture, a physical weight that settled into the shoulders and behind the eyes and made the simple act of keeping a car on the road feel like something requiring active concentration. She had been in the state capitol for 3 days, attending the annual Federal Judicial Conference on Criminal Justice Reform, a gathering of district judges, appellate clerks, legal scholars and policy advisors convened to examine, among other things, the rising number of civil rights complaints filed against law enforcement in the Southeast Corridor. The pattern of excessive force, claims that kept appearing in mid-sized county jurisdictions, and the persistent documented gap between how the law read on paper and how it landed on the bodies of ordinary citizens who encountered it at traffic stops, at convenience stores, at gas stations in the middle of the night. She had sat on 3 panels. She had moderated a discussion on body camera compliance and accountability frameworks. She had listened to a federal appellate judge from Georgia describe in clinical, careful language what happens to a community when the people sworn to protect it stop believing the rules apply to them. And then she had gotten in her car to drive home, and the universe, with the particular sense of irony it reserves for moments like these, had decided she needed a reminder that none of what she studied in conference rooms was theoretical. She was not dressed like the Honorable Judge Renata Cole of the Federal District Court that night. She had changed out of her tailored navy suit and into the traveling clothes she kept in a bag in the trunk. For long drives home, an oversized gray university hoodie from her alma mater that had been washed so many times the letters across the chest had started to flake, faded black yoga pants and a pair of scuffed running shoes she wore only when she was too tired to care what anything looked like. Her hair, which she normally wore pinned in a low, precise bun that communicated order and authority without trying to, was pulled back in a loose ponytail that was already half escaped by the time she crossed the county line. She had no makeup on. There was a half-empty gas station coffee from 2 hours ago in the cup holder, cold and untouched since Millbrook. To anyone who passed her on Route 12 that night, she was simply a tired woman driving home. She was 52 years old and had spent the last 23 of those years in law, first as a public defender in Atlanta, working 100-hour weeks for clients who could not afford to breathe wrong in a courtroom, then as a prosecutor, then as a district court judge appointed by a federal commission that had described her in their formal recommendation letter as possessing a legal mind of uncommon precision and an instinct for fairness that other jurists spent entire careers trying to develop. She had presided over federal cases involving civil rights violations, organized corruption, wrongful conviction appeals, and officer misconduct. She had read 10,000 police reports. She knew what lawful procedure looked like, and she knew what it looked like when someone was manufacturing it. The fuel light chimed on her dashboard somewhere around mile marker 47 on Route 12, a flat, mostly dark stretch of road lined with bare trees and the occasional illuminated billboard. She had been planning to push through to the highway interchange and stop at the big travel plaza, but the light had other ideas. She scanned ahead and saw the glow of a gas station sign, the blue and white of Coastal Fuel, flickering slightly through the tree line about a quarter mile up on the right. She pulled in. The lot was entirely empty. The overhead fluorescent panels buzzed and hummed, and one of them near pump number 2 was dying in the slow, stuttering way that fluorescent lights die, throwing uneven yellow light across cracked concrete that had heaved and split in the winter freeze. The night air hit her when she stepped out of the car, sharp and cold, carrying the faint smell of motor oil and rubber, and the particular dead stillness of a rural commercial lot at midnight. She swiped her card, selected the grade, and picked up the nozzle, and for a long moment she just stood there, listening to the rhythmic clicking of the gas counter and thinking about absolutely nothing, which was the closest thing she'd had to peace in 3 days. The clicking of the gas pump was the only sound in the world, until it wasn't. The cruiser rolled into the Coastal Fuel lot from the north end, headlights off, engine throttled low. Not the entrance of officers responding to a call or conducting routine patrol, but the slow, predatory drift of men with time on their hands and something to prove with it. Deputy Craig Merritt had been with the Oak Haven County Sheriff's Department for 14 years, and in that time he had accumulated exactly the kind of record that should have ended a career, and instead, through the particular alchemy of union protection and supervisory indifference, had merely followed him around like a shadow nobody acknowledged. 7 excessive force complaints, 3 formal misconduct inquiries, an internal affairs review in 2019 that was summarized in 2 pages and then buried in a file cabinet that nobody opened. None of it had stuck. None of it ever stuck to Merritt, because Merritt had learned early that the shield was not just a symbol, it was a transaction. The badge bought loyalty from above and fear from below, and as long as you understood that dynamic and worked it correctly, you could operate in whatever way you chose and call it procedure afterward. He was broad across the shoulders in the way that comes less from fitness than from a kind of physical density. A man who took up more space than his actual size suggested, because he moved through the world with absolute confidence in his right to be wherever he was and do whatever he decided to do. His buzz cut was tight and precise. His uniform always fit a little too snugly across the chest, which he had always interpreted as a feature rather than a problem. He was 38 years old and had never once in 14 years on the job been made to feel genuinely accountable for anything. Shane Fowler, riding passenger, was 26 and 18 months into a partnership with Merritt that had already left permanent marks on him, not visible ones, but the kind that show up later in the hesitation before an honest answer, in the way he'd learned to look away at moments that used to make him speak up. He was not a bad person. He had not been one when he started. But Merritt had a talent for making the people around him complicit by degrees, each small surrender making the next one easier to rationalize until the distance between who you were on the first day of the academy and who you were now had grown too wide to comfortably measure. Merritt spotted Renata's car at Pump 4 from the entrance of the lot and slowed to a roll. He tilted his head, studying the scene's silver sedan current registration sticker, a woman alone in casual clothes pumping gas, not looking around, not on a phone, nothing observable. Nothing whatsoever. And yet something in his assessment of the picture, something that had nothing to do with probable cause and everything to do with a calcified prejudice he had long since stopped questioning, registered the image as a problem that needed his attention. "Look at that," he said, not to Fowler, exactly more to the windshield. "She's pumping gas," Fowler said. "She's out here at midnight." "So are we." Merritt didn't answer that. He pulled the cruiser to a stop at an angle that blocked the exit lane of the pump island, cutting off the sedan without being directly in front of it, the way a cat positions itself near a mouse hole without technically doing anything. He killed the engine. "Listen," Merritt said, one hand already on the door handle. "You want to know why I've been on this job 14 years and I'm still standing and half the guys from my academy class are either gone or filing paperwork all day behind a desk? It's because I understand something most of them don't. This badge doesn't mean you serve people. It means you define which side of the line they're on. You move through this county like you belong to it because you do. When you stop believing that you lose the edge, you stop being the law and start being a suggestion. You understand?" Fowler said nothing. He had heard versions of this speech before. "Come on," Merritt said, and pushed the door open into the cold night air. Merritt approached with his hands loose at his sides, not reaching for anything, not needing to the authority of his posture, doing the preliminary work the way it always did with people who were accustomed to stepping aside when they saw a uniform coming. He covered the 15 feet from the cruiser to Pump 4 with the measured confidence of a man who had never once had this kind of approach go wrong. Renata heard the footsteps on the cracked concrete and registered the cruiser in her peripheral vision. Without turning her head, she had noticed it come in, noted its angle, noted the absence of any approaching call on her scanner app, which had been quiet since she crossed the county line. She finished watching the gallons tick over to 7 and waited. "Evening," Merritt said, stopping closer than was necessary, his presence immediately filling the space between her and the pump. His voice had that particular flatness of someone who says a polite word with no polite intention behind it. "Good evening, officers," Renata replied, turning to face him fully. Her voice was steady and clear, the voice of a woman who had spent 23 years in rooms designed to intimidate people into uncertainty and had never once let them. She made brief eye contact with Fowler, who was standing about 6 feet back and slightly to the right, and then returned her attention to Merritt. "Bit late to be out," Merritt said. His gaze moved over her hoodie, her yoga pants, her scuffed shoes. The assessment took less than 2 seconds, and she could read every word of the conclusion he'd already drawn. "Just stopping for gas on the way home," Renata said evenly. She replaced the nozzle on the pump cradle, turned the cap on her tank, and turned back to him without breaking eye contact. "Where you coming from?" "The state capitol. Judicial conference." Merritt's lip twitched slightly at the corner, not quite a smirk, but heading there. "I'm going to need to see some identification." Renata stood still for a moment, her legal mind already moving, categorizing no traffic stop, no observable violation, no articulable suspicion, a consensual encounter that was rapidly becoming an investigatory detention without constitutional basis. She had taught a seminar on exactly this type of encounter to a room full of federal public defenders in 2021. "Am I suspected of committing a crime, deputy?" she asked, her tone measured educational, entirely without aggression. Merritt's jaw set. That slight hardening around the eyes that comes when a man who expects deference gets a question instead. We've had reports of residential burglaries about 2 miles back. You matched the description we were given. It was a lie. Her scanner had been silent. There were no active dispatch calls in this zone, and the vague bureaucratic phrase, match the description, was doing work it had no legal right to do. Renata knew it immediately, the way she always knew it in a courtroom when a witness was building a narrative on air rather than fact. Deputy, I'm not in a vehicle, I'm not in motion, and there is no articulable basis to detain me at a gas station for a burglary in a residential area 2 miles away, she said. Under state law, I am not required to produce identification under these circumstances. At Pump 3, about 20 feet away, a man in a faded work jacket and a baseball cap had paused in the middle of replacing his own fuel nozzle. His name was Walt Greer, and he drove a delivery route 6 nights a week and had developed the particular quiet alertness of a man who spent a lot of time alone at odd hours watching the world happen around him. He was not sure yet what he was watching. He left his hand on the pump handle and did not move. Merritt stepped forward, closing the gap between himself and Renata by another foot, using his physical size the way he always did, not as a threat exactly, but as a demonstration, a reminder of the fundamental physics of the situation. You're going to give me your ID, and then we're going to take a look in your vehicle, or you are going to be in a very serious situation. You do not have my consent to search my vehicle, Renata said, and her voice dropped slightly in register, not louder but denser somehow, carrying a weight that did not waver. And if you continue to detain me without cause, you will be violating my Fourth Amendment rights. What happened next happened fast. Merritt reached out with his right hand, closed it around Renata's left wrist, and yanked her arm behind her back with a force that sent a sharp, white-hot bolt of pain through her shoulder and down into her hand. She did not struggle. She went completely deliberately limp, the way she had once read in a judicial brief on excessive force, that compliance must be total and visible so that there can be no subsequent argument about resistance. The side of her face was pressed against the cold metal of her own car's trunk lid, and the cold shocked through her cheekbone and made her breath catch. "Stop resisting," Merritt announced in a raised voice, the declaration aimed not at her, but at whatever recording might be capturing this moment. "Stop resisting right now." "I am not resisting," Renata said clearly, deliberately loud enough that the microphone on his lapel and the man at Pump 3, who had now taken his phone out of his jacket pocket, could catch every syllable. "I am complying. This is an unlawful arrest. I am requesting your badge number and your partner's badge number." "Fowler," Merritt said. "Cuffs." Fowler hesitated for one visible physical beat. His weight shifted backward. His jaw tightened. And for a moment, something in him that still remembered why he'd wanted to be a cop in the first place tried to assert itself. "Vance, she didn't." "Cuffs, Shane." The steel bracelets clicked onto Renata's wrists with a pressure that was well beyond what the situation required, biting into the skin, and she felt the circulation in her fingers begin to slow almost immediately. She noted it, filed it away in the precise mental inventory she was already building. 12:07 a.m., Route 12. Coastal Fuel Pump, 4. Deputy Merritt. Deputy Fowler, unlawful detention. No reasonable suspicion stated use of force, initiated cuffs, applied with excessive tightness. Witness present at Pump 3, black jacket and cap, driving a truck with partial plate, visible from the corner of her eye. At Pump 3, Walt Greer's phone camera was recording. She was pushed into the back of the cruiser without ceremony, the door slamming shut behind her, and she sat in the dark with her hands pinned behind her back and the cold seeping in through the plastic seat. And she made a decision. Not an emotional one. A strategic one, clear and deliberate, and grounded in 23 years of understanding exactly how institutions work and where they are most vulnerable to truth. She was not going to tell them who she was. Not yet. Precinct 7 on Mercer Street was the kind of building that had been designed in an era when government architecture was not particularly concerned with communicating anything welcoming about the relationship between law enforcement and the public it served. It was concrete and fluorescent light and the permanent low-grade smell of industrial cleaner failing to fully overpower something older and harder to name, and at 12:40 on a Tuesday morning it operated at the particular pitch of institutional fatigue that the graveyard shift always carries people doing their jobs, but only exactly as much of their jobs as the hour required. Sergeant Daniel Bowen had been behind the booking desk for 19 years and had roughly 8 months left until his pension kicked in, and he approached each remaining shift with the singular goal of completing it without incident. He was not a cruel man. He was not a corrupt one exactly. He was a man so thoroughly worn down by decades of institutional routine that the surface had been sanded smooth of any particular moral texture, and what was left was procedure performed without engagement, a human vending machine for paperwork. He looked up when Merritt pushed Renata through the door, glanced at her once the hoodie, the yoga pants, the disheveled ponytail, the flat controlled expression that he registered as either guilt or arrogance, and didn't stop to determine which, and reached for a booking form. "What do we have?" Bowen asked, already clicking into the intake screen. Merritt rattled off the charges with the ease of a man reading a grocery list: disorderly conduct, resisting arrest, refusal to identify suspected connection to the Piney Ridge residential break-ins. He did not look at Renata while he said them. He was looking at Bowen, his expression satisfied in the way of a man who has done a clean night's work. "Name?" Bowen asked, not looking up. "Renata Cole," she said. Her voice was even and unhurried. Bowen typed it in. Address? She gave her home address. Bowen's fingers stopped briefly over the keyboard when she finished. It was a street in the Ashford Gate community, the kind of address that came with a security gate and a HOA and manicured hedgerows, the kind of address that did not typically arrive at Precinct 7's booking desk at 12:40 in the morning attached to a woman in yoga pants. His eyes moved to her and back to the screen, and whatever question almost surfaced in his mind sank back beneath the surface of his administrative fatigue without breaking through. He stamped the form. "Personal effects go in a bag," Bowen said to Fowler. "Cell 3 is available. We'll process her prints once the system update finishes." Renata's phone keys and wallet were dropped into a manila evidence envelope. Merritt tossed the wallet in without opening it. If he had opened it, he would have found behind her driver's license and 2 credit cards, her Oak Haven County Federal District Court judicial identification and her State Bar Association card with the gold embossed seal. He would have seen the title printed in small, precise text beneath her photograph, "The Honorable Renata Cole, United States District Court Judge." But he did not open it. He did not think the contents of the wallet of a woman in sweatpants at a gas station were worth inspecting. He sealed the envelope with one practiced fold and set it in the tray, and that small act of contempt, the assumption that there could be nothing worth knowing inside, would cost him everything. She was walked down a long hallway that smelled of bleach and something older and more institutional beneath it, past a row of closed doors and a bulletin board with outdated notices, and delivered to holding cell 4. The door was heavy iron bars, and when it closed behind her, the lock engaged with a solid mechanical finality that she felt in her chest more than heard. She stood alone in the cell and did not move for a moment. The ceiling held a single bare fluorescent tube. In the upper left corner, mounted at a downward angle, was a black dome security camera. A small red light blinked steadily inside it. She noted it and sat down on the cold metal bench and began to remember everything. The night officer who responded to her request for writing materials was a young woman named Dana Webb, who brought a yellow legal pad and a pen with the cap missing without asking any questions, and stood at the bars for a moment after handing them through with the careful, slightly guilty expression of someone who wants to say something but hasn't decided whether they're allowed to. "Thank you," Renata said, quietly, with the kind of genuine warmth that doesn't change its temperature based on circumstances. Dana Webb nodded and left. She came back past twice in the next 2 hours, and each time slowed her pace at the cell, and each time Renata was writing bent over the yellow pad with a focus that looked nothing like the posture of someone waiting to be rescued. Renata wrote everything, not in the breathless, disorganized way of someone processing a crisis, but in the methodical, structured way of a judge building a record. The exact time she pulled into the coastal fuel lot, the exact time the cruiser appeared, the angle of its approach, the words Merritt used before physical contact, the words she used, the position of the witness at pump 3, the dark jacket and baseball cap, and the partial plate she'd caught in the edge of her vision, the specific sensation of the handcuffs applied above the level of reasonable restraint, the documentation she could feel building in the developing bruises on her wrists, the charges read by Sergeant Bowen, which bore no connection to anything she had done. She wrote in small, clear print, filling 2.5 pages without pause. In the cell adjacent to hers, separated by a solid concrete dividing wall with a narrow barred window at eye level. If you stood close, a woman had been sitting in near silence since before Renata arrived. Her name was Dolores, and she was 61 years old, and she had been brought in that evening after her ex-husband had called the police, claiming she had violated a restraining order he held against her, an order that Dolores's own attorney had been contesting as fraudulently obtained for the past 3 months. She was waiting for a morning hearing that would either free her or extend the nightmare that had been her life since the divorce. She had the quality of a woman who had been carrying a very heavy thing for a very long time and had stopped expecting anyone to offer to help with it. They spoke quietly through the barred divider. Not about law, not about rights. About what it actually felt like to be in a room like this. The cold, the disorientation, the way time moved differently when you were not in control of, when the door opened, the way the removal of your phone and your keys felt like a removal of your own continuity, like being cut loose from your own life and left floating. "First time?" Dolores asked at some point past 2 in the morning. "Yes," Renata said. "It doesn't get easier," Dolores said, "but you get clearer. You figure out real fast what's actually solid and what was just borrowed authority." Renata sat with that for a moment in the particular unadorned way of someone who is hearing a truth they already knew but needed to hear said plainly. She thought about every defendant who had sat in a room like this before walking into her courtroom. She had read about these rooms. She had issued rulings that sent people to rooms like these. She had believed she understood them in the way that careful study and genuine empathy can build an approximation of understanding, but understanding and knowing are not the same weight. The cold of the bench beneath her, the stale chemical smell, the blinking red light of the camera in the corner, the distant footsteps and the random mechanical sounds of the building at night, these were not things that translated into briefs and affidavits. They lived in the body. She would carry this in her body from now on. She was certain of that. Sometime around 3 in the morning, she made the decision formally, the way she made all important decisions, not impulsively, but after reasoning through it, completely weighing every alternative outcome against every available fact. She would not identify herself. Not because she feared what Merritt might do if she did, but because she had seen with absolute clarity what would happen. There would be an immediate panicked reversal. Profuse apologies, calls to her husband, humiliating backpedaling, and by morning Craig Merritt would be back in that precinct telling himself it was an honest mistake, and the next person at the next gas station at the next midnight would have no one standing between them and whatever he decided to do. No. She was going to let them build this. She was going to let every word land in the record, let the machine run on its own tracks, let them walk themselves right up to the edge. And then she was going to be standing there at the other side when they looked up. She folded the legal pad pages carefully and tucked them into the front pocket of her hoodie. Then she leaned back against the cold concrete wall and waited for morning. The sunlight that came through the blinds of Craig Merritt's apartment on Tuesday morning was the kind of clean, uncomplicated brightness that makes a person feel briefly that the world is a sensible place and everything in it is proceeding according to a fair and logical order, which was precisely the kind of feeling that Craig Merritt had cultivated throughout his entire professional life and had no particular reason to question that morning. He woke up feeling, as he often did after a shift that had gone to his satisfaction, like a man who had done his job and done it well. He made coffee black in the same chipped mug he used every morning, and he stood at the kitchen counter in his undershirt and thought with the comfortable smugness of a memory you don't need to perform because you're alone about the woman at the coastal fuel station. The way she'd quoted constitutional law at him like that was going to do anything. The look on her face when he'd moved her toward the cruiser, that cold, still expression she'd held the whole time, like she was above the situation, like she hadn't figured out yet that being above the situation was not a position available to people who end up in holding cell 4. He picked up his phone and texted Fowler. Hope, our gas station constitutional lawyer, enjoyed her concrete breakfast. Court at 9. Easy day. Fowler's response came back after 2 minutes, a single thumbs up. Merritt changed into his uniform, buckled his belt with the practiced ease of 14 years of muscle memory, checked his reflection in the narrow bathroom mirror with the flat, assessing look of a man who approves of what he sees, and drove to the courthouse. Glenn Forsythe, the Oak Haven County Sheriff's Department union attorney, was waiting outside the heavy oak doors of courtroom 4A at 8:50 with a folder of documents and a pressed suit, and the particular energy of a man who was very good at his job and knew it. He handed them each a copy of the relevant sworn affidavit for the day's hearing, State versus Marcus Pemberton, a motion to suppress, arising from a traffic stop 3 months earlier, in which Merritt had, in his official report, described a set of circumstances that bore a notable resemblance to a different set of circumstances from the night before, and walked them through the expected questions and answers in the brisk, confident shorthand of a legal professional who had done this particular favor many times. Judge today is Cole, Forsythe said, checking his notes. She's a stickler for procedure, but she's not reflexively anti-enforcement. You stick to the affidavit language, you answer directly, you don't editorialize, you're fine. Cole, Merritt said. He thought for a moment. Isn't that Holloway's rotation? Holloway's out this week. Cole is covering the Tuesday docket. Forsythe straightened his tie. Heard she's sharp, but she tends to rule on the facts. We have the facts. Let's go. They pushed through the heavy oak doors and walked to the front row behind the prosecution table and sat down, and Merritt crossed his arms and allowed himself a small private moment of something that was not quite confidence, because it had never occurred to him to doubt the outcome. It was more like the absence of concern, a blank space where worry might have lived in a man who had ever been meaningfully accountable for anything he'd done in 14 years of work. He did not know what was behind the door at the back of the courtroom. He did not know who had been in that building since 7:30 that morning preparing. He was about to find out. Lawrence Cole had been a civil litigation attorney for 26 years, and in that time he had developed the professional ability to remain visibly composed in almost any circumstance, which was why, when he walked out of the precinct, 7 lobby at 6:15 that morning with his wife at his side, and saw the bruises wrapped around both of her wrists like dark mottled bands visible even in the gray early light. When her sleeves shifted, the composure it took him not to turn around and walk back inside and say every word he was thinking cost him more than anything a case had ever cost him. He draped his overcoat over her shoulders instead, and they walked to the car, and he drove home, and he did not speak until she was sitting at the kitchen table with a cup of tea between her hands and the yellow legal pad pages laid flat in front of her. And then he said quietly, "Tell me." She told him everything from the cruiser rolling in to the cuffs, to the booking desk, to Dolores, to the ceiling camera in cell 4, and Lawrence sat across from her and listened. The way he always listened, completely without interrupting, taking it in as evidence rather than as emotion, because that was the only way he knew to hold this much anger without letting it become something destructive. "I can have them suspended by noon," he said when she finished. "I can have the sheriff's department brass on the phone in 45 minutes. You do not have to go in today, Renata. Judge Hargrove can take your docket. You were assaulted." "I know," she said. "Then let me, Lawrence." She set down the tea and looked at him directly. "If I call in today, Merritt spends the morning in that courthouse believing he taught a lesson last night. He goes home feeling like the system ran the way it's supposed to run for people like him. And then he does this again. Next week, next month. To someone without a legal pad." She held his gaze until she was sure he understood. "He's on my docket today. He's going to walk into courtroom 4A not knowing I spent the night in cell 4 and walk out knowing exactly what that decision cost him. I need to be the one in that room when it happens." Lawrence looked at her for a long moment. Then he said, "Okay," and stood up, and that was all. She showered and dressed, and when she stood in front of the bathroom mirror in her blouse and slacks, she looked at the bruises on her wrists. They had deepened overnight, a dark purple and green ugly and unmistakable against her skin, and she did not reach for the concealer in the cabinet. She reached instead for the heavy velvet hanger on the hook behind the door and lifted down her judicial robe, the black fabric dense and substantial, and slid her arms into the wide sleeves and felt the weight of it settle across her shoulders, the way it always did, like something closing into place. The sleeves came down past her wrists. The bruises disappeared. She stood in front of the mirror and looked at herself for a moment. Not at the bruises, not at the tiredness behind her eyes, but at the whole of her. The woman who had walked into a gas station the night before and been treated like she was invisible and unknowable and powerless, and who was about to walk into a courtroom and demonstrate with the precision of someone who had spent 23 years understanding exactly how truth lands when it's delivered correctly, precisely what power looks like when it does not announce itself. She reached into the pocket of the robe and smoothed her hand over the folded pages of the legal pad. They were still there. She was ready. Captain Ray Aldridge had been the commanding officer of Precinct 7 for 11 years, and he had spent most of the last 14 of those hours in a state of controlled emergency that he was not permitted to show on his face. He had been notified at 7:20 that morning when the day shift clerk processed the overnight property envelopes and opened the manila bag belonging to one Renata Cole and found behind a standard driver's license a federal judicial identification card with a photograph and a title and a court assignment that made the clerk physically push back from her desk and read the card again before picking up the phone. Aldridge had spent the following 2 hours making calls he hoped could contain the damage and arriving at the certain sickening conclusion that nothing could. He had driven to the courthouse. He had tried to get there before the session began. He was running in the literal sense through the marble corridor of the Oak Haven District Courthouse at 8:58 when he saw the heavy oak doors of courtroom 4A already closed and understood that he was 2 minutes too late. Inside, the morning session was assembling itself with the ordinary procedural choreography of a Tuesday docket. The gallery murmured at low volume. Attorneys reviewed notes. The court reporter set up her equipment. Defense attorney Darius Holt, representing Marcus Pemberton on the motion to suppress, was a composed, deliberate man who had practiced criminal defense for 18 years and had the particular quality of a person who pays attention to everything while appearing to pay attention only to his immediate task. He arranged his documents in the order he intended to use them and waited. Prosecutor Naomi Wells sat at the state's table and wrote 2 lines in her legal pad and then stopped writing and looked at the back wall for a moment, turning something over in her mind that she had not quite resolved. In the front row behind the state's table, Craig Merritt sat with his arms crossed and his legs spread in the unhurried posture of a man who expected this morning to require nothing from him. Shane Fowler sat next to him, one hand on his knee, looking at the floor, with the expression of someone who had been trying to talk himself out of a vague, sourceless unease since he woke up. At 8:59, Captain Aldridge pushed through the heavy oak doors. His face was the color of old paper. His eyes found Merritt and Fowler in the front row, and the look that passed over his face in that instant, a look of such unmediated, helpless dread, should have communicated everything to anyone in the room who happened to be watching him. But Merritt was not watching him. Merritt was looking at his phone. Aldridge started moving down the center aisle, shouldering past a public defender with a hurried apology, his mouth already forming words. And then the bailiff's voice cut through the room from the front. All rise. Aldridge stopped. The door at the back of the judge's bench opened, and Judge Renata Cole walked out. She moved with the measured, unhurried grace of a person who has spent 2 decades entering rooms designed to communicate authority and has long since stopped needing to think about what that walk looks like. The black robe settled around her as she ascended the 2 steps to the bench, and she stood at the center of the elevated mahogany desk and looked out over her courtroom with an expression of complete, unreadable neutrality. The face that 23 years of judicial practice had trained into a kind of professional perfect stillness, betraying nothing, receiving everything. In the front row, Craig Merritt sat down with the rest of the room and leaned back, the habitual comfort of a man who is not expecting the situation to require attention. He glanced toward the bench to get a read on the judge the way he always did, a quick look, a fraction of a second, a professional calibration. The fraction of a second stretched. His brain processed the image, and something in it, the specific proportion of the face, the particular quality of the stillness, the way the eyes held absolutely still, sent a signal that did not make immediate sense. He looked more carefully. The hair was different, the clothes entirely different, the posture formal and elevated rather than tired and casual. But the eyes were the same eyes that had looked at him over the trunk of a silver sedan at 12:07 this morning and told him with no anger and no panic and no particular urgency exactly what he was doing and why it was wrong. The air left his lungs in one complete involuntary evacuation. His hands found the wooden railing in front of him and gripped it with the instinctive desperation of a man trying to establish that the ground is still solid. His knuckles went white. He leaned forward by an inch, and then another, as if proximity might correct what his eyes were telling him, as if closer inspection might produce a different conclusion. It did not produce a different conclusion. Next to him, Shane Fowler had been watching Merritt's face because the sudden change in the quality of Merritt's presence, that thing that happened when all his certainty left the room at once, was viscerally felt even without looking at the bench. Fowler looked up. He made a sound that was not a word. It was something that happened to him before language arrived, a soft, involuntary collapse of air from a chest that had just received information it did not know how to process. He turned to Merritt. His face was the color of chalk. "Craig," he whispered, and his voice shook. "Craig, that's—" "I know," Merritt said, very quietly. He had not moved. He was still gripping the railing. At the back of the room, Captain Aldridge had stopped moving entirely, standing in the center aisle with his hands at his sides, watching the 2 men in the front row understand what they had done, and the expression on his face was the expression of a man watching a building collapse that he did not build and cannot stop. At the bench, Judge Renata Cole adjusted her microphone with 2 precise movements, opened the folder in front of her, and arranged her pens. She did not look at the front row. Not yet. She let the silence run out to its full length, let it fill the room, let it do what silence does when it has weight behind it. Then she looked up. She looked directly at Craig Merritt, and the thing in her eyes was not anger. There was no anger in it, no vindictiveness, no performance of injury or triumph. What was in her eyes was something far more specific and far more final than any of those things. It was the cold, certain mechanical knowledge of a trap closing with the precision of something that has been waiting patiently a very long time. "Good morning, counsel," she said, and her voice was smooth and level and completely steady. "We will begin today's docket with the evidentiary hearing on the motion to suppress in the matter of State versus Pemberton. I understand we are examining the conduct and the constitutional basis of the arresting officers." She paused for exactly 1 beat. "I see Deputies Merritt and Fowler are present. Deputy Merritt, please approach the witness stand. Let's discuss your understanding of the law." The walk from the front row to the witness box was perhaps 15 feet, and Craig Merritt covered it in the manner of a man whose legs are receiving instructions from a brain that is simultaneously attempting to perform several incompatible functions. Maintain outward composure rapidly. Assess available exits. Calculate whether there is any version of this that ends differently than it is currently ending, and process the foundational impossibility of the situation without physically expressing what any of those calculations are producing. There were no exits. There was no version. He sat down in the witness box and placed his hand on the Bible and swore an oath, and the sweat that broke through his shirt the moment the oath was complete was visible at the collar. Attorney Darius Holt rose and began with a careful, methodical series of questions about the Pemberton stop, the articulated suspicion, the observable behavior, the decision to escalate to physical contact, and Merritt answered them in the clipped, practiced language of a man reciting from a script he had memorized in the hallway 40 minutes earlier. He was managing it. He was holding the shape of the thing together. And then Judge Renata Cole leaned forward and said, "Deputy Merritt, I'd like to pursue a line of hypothetical questioning to establish the foundation of your constitutional understanding. Mr. Holt, if you'll permit the court to lead for a moment." Holt, who had been watching the judge with the sharp lateral attention of someone who had noticed something shifting in the room but not yet identified exactly what, sat down with a small nod. "Hypothetically speaking," Judge Cole began, her voice taking on the precise, deliberate cadence of a professor constructing an argument brick by brick. "Suppose a citizen is standing at a gasoline station at approximately midnight. They are alone. They are not in a vehicle. They are pumping fuel. There is no active dispatch call in the area. There is no observable illegal activity of any kind. Under your interpretation of the Fourth Amendment and state detention law, does a law enforcement officer have the legal basis to compel that individual to produce identification?" Merritt felt the question land on him with the specific, irreversible weight of something he recognized but could not yet fully articulate the dimensions of. "No, Your Honor," he said carefully. Not just for being at a gas station." "Excellent," Cole said with a precision that was not warmth. "Now let us advance the hypothetical. The individual, when approached, declines to produce identification, citing the absence of reasonable articulable suspicion. She does so politely, without aggression, without threatening behavior of any kind. Under the law, as you understand it, does a lawful invocation of constitutional rights constitute disorderly conduct or resisting arrest?" At the Union attorney's table along the side wall, Glenn Forsythe had stopped reviewing his notes. He was very still, and the stillness had a quality of dawning dread that was distinct from his usual professional composure. He leaned forward slightly, his eyes moving between the judge and his client on the stand. "No," Merritt said. His voice was thinner now. "That alone wouldn't constitute no." Cole said. She turned her pen slowly between her fingers, an unhurried motion. "One more layer. Suppose the officers in this hypothetical, upon having their demand refused on constitutional grounds, respond by physically restraining the individual, seizing her wrist, forcing her against her own vehicle, applying handcuffs with sufficient force to cause visible contusions on both wrists. Despite the fact that she has not made any threatening gesture, has not attempted to leave, and has remained throughout the encounter verbally cooperative and physically passive. Would you characterize that escalation as standard operating procedure? Or would you characterize it as aggravated assault and a deprivation of rights under color of law?" The courtroom, which had been operating at the low background hum of professional attention, had gone entirely quiet. The court reporter's fingers were moving, but her eyes were on the judge. Prosecutor Naomi Wells had set her pen on the table and was sitting very still, and the expression on her face had passed through several stages in the last 90 seconds and arrived somewhere that looked like a woman working to keep her reaction professional while processing something that was making her profoundly sick. Merritt opened his mouth. Nothing came out. Forsythe stood up abruptly. "Objection, Your Honor. This hypothetical is entirely removed from the facts of the present hearing and is designed to—" "Mr. Forsythe," Judge Cole said, and her voice didn't rise, didn't sharpen, didn't change in volume at all, and somehow that made it more final than a shout. "You are here as the deputy's union representative. You are not counsel of record for this hearing. If you address this bench without being recognized again, Bailiff Henderson will escort you to a holding cell for contempt." She held his gaze for a fraction of a second longer than necessary. "I am intimately familiar with what a holding cell in this county feels like. Are you?" The room went a full degree quieter. Forsythe sat down. "Deputy Merritt," Cole said, "the question stands." Merritt was sweating through his uniform in earnest, now a dark ring visible at his collar, his hands white-knuckled on the edges of the witness box. That would constitute excessive force, Your Honor. In the hypothetical." "In the hypothetical," Cole repeated very quietly, letting the phrase exist in the room without help. Then she raised both hands from beneath the bench and placed them flat on the mahogany surface in front of her. The wide black sleeves of her robe falling back to the mid-forearm, and the dark mottled purple and green bruising encircling both of her wrists was laid out under the courtroom's unforgiving fluorescent light in absolute undeniable photographic clarity. The sound that moved through the gallery was not a gasp exactly. It was something more physical than that, a collective involuntary intake that represented 30 people's bodies responding to information before their minds had finished processing it. The court reporter's fingers stopped. Darius Holt, who had been watching with the carefully controlled expression of an experienced defense attorney encountering an unexpected development in his favor, allowed himself a single slow blink. Naomi Wells pushed her chair back from the state's table, and the scrape of the chair legs on the polished floor was the loudest sound in the room for a full 3 seconds. Merritt stared at the bruises. They were his. The exact circumference of the restraints he had applied in the exact place he had applied them, in the exact color that develops when steel is pressed into skin with force and left there for hours. They were his signature, written on a judge's wrists and displayed in open court at 11:14 on a Tuesday morning. "Deputy Merritt," Cole said, leaning forward slightly so that her voice, though still measured, found the back wall with complete ease. "I want you to understand something with absolute clarity. This court finds it extraordinarily difficult, based on your sworn testimony today and on the physical evidence currently visible on this bench, to take your word about anything." In the front row, Shane Fowler stood up. His chair shrieked against the floor. The sound startled 3 people visibly. He was on his feet before he had a coherent plan for what to do once he was there, operating on the pure physical momentum of a fear that had been building since 6 this morning and had finally broken through every rational barrier he had left. His hands were shaking. There were tears on his face, actual tears, moving through the cold sweat on his cheeks. "Your Honor, please." His voice cracked on the second word. "I told him. I said to him in the parking lot, I said, 'Are you sure about this?' I didn't want to put the cuffs on. I swear to God he made the call. He said she was nobody. He said, 'Deputy Fowler.'" Cole's voice did not rise. It didn't need to. It cut through Fowler's unraveling like a blade through silk, clean and immediate, and he stopped speaking mid-sentence. "You will sit down. You will not speak unless I address you directly. And as an officer of this court, I am obligated to inform you that you are currently spontaneously and on the public record admitting to participation in a felony. I strongly advise you to exercise your Fifth Amendment right against self-incrimination before you say anything further." The room absorbed this. The profound specific weight of it. The judge, whose rights had been stripped the night before, now in open court, protecting the constitutional rights of the man who had helped strip them, settled over the gallery with the silence of something that could not be argued with. Fowler looked at her. His face was a wreck. He sat down slowly and buried his face in his hands, and his shoulders began to shake with the silent, terrible movement of a man who has fully understood what he has done and cannot find a way back from it. At the back of the room, Captain Aldridge had not moved from the center aisle. He was standing very still and looking at the front of the room, and looking like a man watching something he was responsible for and could not stop. Naomi Wells stood up from the state's table with the careful, deliberate movement of someone who has made a decision and intends to make it cleanly and without flinching. She had been a prosecutor for 11 years, and she had built her reputation on two things: an aggressive, evidence-driven style in the courtroom and a zero-tolerance position on dirty evidence, because she had seen too many times what happened to the integrity of every case she touched when it was contaminated at the source. She straightened her jacket. She looked at Craig Merritt on the witness stand with an expression that communicated without ambiguity what she thought of what she had just understood. "Your Honor, Wells," said her voice clear and measured for the court reporter's transcript, "the state relies on the sworn testimony and integrity of law enforcement as the foundation of every prosecution it brings. In light of the evidence presented through this court's line of questioning, and the physical evidence currently visible on the court's person, and the spontaneous admissions made by Deputy Fowler, the state is no longer able in good conscience to present these officers as credible witnesses in any proceeding." She paused, allowing it to land completely. "The state formally withdraws Deputies Merritt and Fowler as witnesses. Furthermore, the state will not proceed with the prosecution of Marcus Pemberton, as the entire evidentiary basis of his arrest rests solely upon the word of individuals whose credibility has been irreparably compromised. The state moves to dismiss all charges against Mr. Pemberton with prejudice." Darius Holt was already on his feet. "The defense joins the motion and supports immediate dismissal with prejudice, Your Honor." At the defense table next to Holt, Marcus Pemberton, a 29-year-old man who had been facing 18 months in state prison based on a police report built entirely on Craig Merritt's word, let out a breath that had been held in one form or another for 3 months. His head dropped to the table. His hands came up to cover his face. His shoulders moved once and then again. Judge Cole looked at him for a moment, not at the attorneys, not at the deputies, just at Marcus Pemberton, and her expression shifted almost imperceptibly into something that was not quite warmth, but was its near neighbor. "Motion granted," she said. "All charges against Marcus Pemberton are dismissed with prejudice. Mr. Pemberton, you are free to go." Then she looked at Bailiff Henderson. "Please secure the main doors. Nobody leaves this courtroom." The deadbolts on the heavy oak doors at the back of the gallery engaged with 2 sharp metallic sounds. Clack, clack. The sound rolled through the silent room, and Craig Merritt, who had heard this particular sound many times in his career and had always been on the handing out end of what it meant, felt it land in his stomach like something cold and dense. Cole stood. She did not step down from the bench. She remained elevated, the black robe draped around her, and the room below her felt very small. "The power granted to law enforcement in this state is not a personal privilege," she said, and her voice filled the room without effort, the way it always did when she spoke from the bench about something that mattered. "It is a trust extended by the public in exchange for protection. When a deputy uses that trust, that badge, that uniform, that authority not to protect the public, but to humiliate a citizen in the dark because she knew her rights and he did not want to hear them, that is not a misunderstanding. That is not a mistake in judgment. That is a fundamental corruption of the purpose of the office." She raised her hands one more time, the bruises plain and visible. "Last night, Deputy Merritt and Deputy Fowler detained a woman at a gas station without cause, physically assaulted her, falsely booked her on manufactured charges, and placed her in a holding cell. They did these things because they believed she was powerless." She lowered her hands. Her eyes found Merritt on the witness stand, and she held them there. "Deputy Merritt, you told your partner I was nobody." She let that sit in the room for a single complete beat. "You were right about one thing. Last night I was nobody, and nobody just ended your career." The doors at the back of the room opened. Investigator Frank Driscoll of the State Attorney General's Office of Internal Affairs walked down the center aisle with 2 state troopers flanking him, moving with the particular purposeful quiet of men who have done this before and take no pleasure in it. Behind them, looking depleted and gray, was Captain Aldridge. Driscoll stopped at the wooden railing and looked up at the bench. "Judge Cole, with the court's permission." "Proceed, Investigator Driscoll." He walked through the gate and stopped at the witness stand. He did not look at Merritt with anger. The look was more clinical than that the look of a man performing a necessary and overdue procedure. "Deputy Craig Merritt," Driscoll said, "you are hereby relieved of duty, effective immediately pending criminal investigation by this office, and referral to the United States Attorney for violations of Title 18 U.S.C., Section 242, deprivation of rights, under color of law, as well as aggravated assault, false arrest, and falsification of official records." He reached out and unclipped the silver Oakhaven County Sheriff's star from Merritt's chest. The pin snapped free with a small, clean sound that was somehow louder than the room should have allowed it to be. "No," Merritt said. "It came out thin and without force." "No, you Driscoll, listen. It was she didn't tell us. We didn't know. We couldn't have known who she—" "You knew she was a citizen?" Driscoll said without inflection. That was enough. The troopers managed Fowler in the front row with quiet efficiency, badge removed, belt disarmed, no ceremony. Both men, stripped of everything that had allowed them to believe the rules did not apply to them, looked extraordinarily ordinary. Small, almost. Just two men in uniform shirts with empty chests where the shields had been. As they were walked up the center aisle toward the secured doors, Merritt stopped and turned back. One last look at the bench, at the woman in the black robe sitting at the elevated mahogany desk, looking back at him with the same absolute unperturbed steadiness she had shown him in the gas station lot 12 hours earlier when he had thought she was nobody and had been wrong in a way he was going to spend the rest of his life understanding the full dimensions of. Judge Renata Cole picked up her gavel. "This court is in recess." The sound of the gavel striking the block rang out once clean and final and loud, and it was still reverberating in the high-ceilinged room when the oak doors closed behind Craig Merritt for the last time. The investigation moved with a speed that surprised people who did not know how these things work when the evidence is good and the political will is present, and someone in a position of authority is personally motivated to see it through completely. Walt Greer, the delivery driver who had been at Pump 3 of the Coastal Fuel Station the night before, had driven to the State Attorney General's office that same Tuesday morning with his phone and 6 minutes and 43 seconds of clear, steady video footage that captured the entirety of the encounter from approach to handcuffing. The footage showed Renata Cole standing at a gas pump, hands visible, making no aggressive movement of any kind, and it showed Craig Merritt crossing the space between them and making contact before any legally sufficient justification existed for doing so. The footage was in the language of the investigative summary unambiguous. The text message Merritt had sent Fowler that morning. "Hope our gas station constitutional lawyer enjoyed her concrete breakfast" was recovered from both phones and entered into the evidentiary record as documentation of conscious awareness and post hoc mockery that removed any remaining basis for a good faith argument. Shane Fowler, facing federal charges that carried significant prison exposure and having already put himself substantially on the record in Courtroom 4, accepted a plea agreement within 10 days. He agreed to resign from law enforcement permanently, surrendered his pension, and was sentenced to 2 years of supervised probation with a federal civil rights compliance requirement. He would never carry a badge again. He was 26 years old, and the thing he had let happen to him in 18 months under Craig Merritt's supervision was going to follow him for the rest of his life in the form of what he had allowed himself to become. Merritt did not make it easy. His union-funded defense attorney attempted qualified immunity arguments and good faith exception filings that the federal district court rejected in succession, each motion denied in rulings that cited the video footage, the text message, and the detailed contemporaneous notes written on a yellow legal pad in holding cell 4 between approximately 1 and 4 in the morning. Merritt was convicted on all 3 federal counts and sentenced to 4 years in a medium-security federal facility, standard classification for a former law enforcement officer. No protective housing, the same environment he had sent other people to for years with the casual authority of a man who had never once imagined the position reversing. Captain Aldridge was formally censured and retired under a cloud he would not escape. Precinct 7 was placed under a federal monitoring agreement. 6 weeks after the Tuesday that changed everything on a Wednesday afternoon in October, when the light was going golden and the air carried the first real bite of the coming winter. Judge Renata Cole walked down the front steps of the Oakhaven County District Courthouse in her street clothes, charcoal slacks, a dark red wool coat, her leather bag on her shoulder, moving through the end of her workday the way she always did, unhurried and thinking. There was a woman sitting on the low stone bench at the base of the courthouse steps. She was 61 years old and was dressed simply a dark coat and sensible shoes, and she was holding a folded piece of paper in both hands with the careful attention you give to something you've been thinking about for a while. It was Dolores. The case had been reviewed by a different judge the week after the arrest. Dolores's attorney had filed an emergency motion citing the circumstances that had come to light about Precinct 7's practices, and the fraudulent restraining order had been overturned. The ex-husband's manufactured complaint had unraveled under a 14-minute hearing. Dolores was going home. She had been going home for 3 weeks now, and what that meant, what it actually felt like after the years of it not being true, was something she was still learning how to carry. She did not know who the woman walking down the steps was. She had not seen Renata in a robe or in a newspaper photograph. She had only seen her through a barred divider at 3 in the morning in a gray hoodie speaking quietly in the dark. But she looked up when the footsteps neared, and she looked at Renata's face, and something in the stillness of it, that particular unfrightened quality. The eyes that didn't flinch from contact stopped her. Renata stopped too. They looked at each other for a moment in the golden afternoon light on the courthouse steps, and there was no performance in it, no ceremony. Just two women who had been in a cold room together at the worst hour of a difficult night and had both found their way to the other side of it. Dolores unfolded the piece of paper she was holding and held it out. Renata took it. It was a handwritten note on the kind of lined paper sold in dollar store spiral notebooks, 3 sentences in careful, deliberate handwriting. You sat with me when I was invisible. I wanted you to know that somebody saw. Thank you. Renata read it once and then held it in both hands for a moment, standing still, the courthouse behind her and the city moving along its ordinary Tuesday afternoon business ahead of her. And she thought about Dolores in Cell 5 and Marcus Pemberton at the defense table, and every person she had ever sentenced or released or redirected from that bench, while believing she understood in the abstract what those rooms felt like on the inside. She reached into the inner pocket of her coat and took out the folded yellow legal pad pages, from that night the ones she had written at 2 in the morning with a borrowed pen, the ones she had carried since not as evidence but as something else. She looked at them for a moment, then folded them carefully one more time and tucked them into the pocket of her slacks, close where she would feel them. She looked at Dolores. "How are you doing?" "Better," Dolores said. "Slowly, but better." Renata nodded. "That's the right pace." She walked down the remaining steps and out into the afternoon, and behind her the courthouse sat solid and stone-faced in the October light, full of people navigating the particular kind of hope and terror that come from standing before a system that can either protect you or consume you, depending on factors that have nothing to do with what you deserve. She thought about all of them, and she thought about what a cell teaches you that a courtroom cannot. And she thought about what it means to carry that knowledge in your hands and use it carefully every single day for as long as you are given the chance. Judge Renata Cole had not revealed her identity at the gas station because she was waiting not passively, not in defeat, but with the deliberate, clear-eyed patience of someone who understood that the truth lands harder when it arrives on its own terms. She waited, and she wrote it all down, and she let morning come. And when justice called, she was standing on the bench in her robe with the evidence written on her own wrists, and she answered it the way she had answered every call in 23 years, completely, and without flinching. If this story stayed with you, if you've ever had to wait for the truth to catch up, or if you've ever called out something wrong in a room where it cost you something to do, tell us about it in the comments below. Stories like this remind us that power doesn't always come announced, and that the person being dismissed as nobody is sometimes the most dangerous person in the room. Subscribe to our channel so you never miss the next one. We'll see you there.